So this is thanks to our media partner, National Business Daily, one of the most influential financial media in China. So actually, we have discussed about intellectual property protection before in different topics. For example, in digital economy in our second episode, and the cross-border commerce and trade in our first webinar. Today, we are going to talk about a very special topic. It's about the IP protection in the medicine and the healthcare industry. This is because some of our clients from the pharmaceutical and healthcare are facing the IP challenges. So we would like to take this 1.5 hours to hear more valuable experiences and advice from today's speakers. We are very honored to have 3 IP experts sharing interesting actual cases and views from their own perspectives of the IP protection in medicine and healthcare. So later on, we have also the possibility to ask questions via the Zoom meeting, via chat, to our speakers, and they are all ready to answer the question in the chat room. I think something wrong with our live stream. So is everything okay within our Zoom meeting, right? Hello. 它一直在重新断，重新连。Okay. So let's continue with our webinar today. I think something wrong with our live stream. So let's continue. So we also have the possibility to ask questions via our Zoom chat to our speakers. And they are all ready to answer the questions in the chat room. But later on, we have the moment for the Q&A session where you can raise your hands and ask questions accordingly. So first, let's welcome Ms. Wei Qing, a representative of International Commercial Disputes Prevention and Settlement Organization, ICD-PASO, an international organization who help to protect trade and investment entities in dealing with uncertainties and risks and ensure commercial disputes will be fairly solved. Naturally, intellectual property protection is one of their major focus, and we, EUCGIC, as the first bench of the members, are also ready to provide service and help to our companies. So first, let's welcome Ms. Wei Qing.
Okay, thank you, Shasha. I'm Wei Qing from ICD-PASO. Distinguished guests, dear friends, good afternoon. It's a great honor to be invited to the forum on IP protection in medicine and healthcare industry. First of all, on behalf of Dr. Liu Chao, Secretary General of International Commercial Dispute Prevention and Settlement Organization, I would like to extend our sincere welcome to all the guests attending the meeting, and also express our cordial gratitude to EU-China Joint Innovation Center, one of the founding members of ICD-PASO, for their efforts to organize this meeting. ICD-PASO, a non-governmental international organization, was established in October last year in Beijing, China. It mainly provides legal service from commercial dispute prevention to dispute settlement, including arbitration and mediation. ICD-PASO aims to protect the legitimate rights and interests of parties and strives to create an efficient, convenient, fair, and just business environment. Therefore, IP protection is also one of the key tasks of ICT puzzle. Health is the foundation of social civilization and progress, especially after the COVID-19 pandemic. The international community has reached a consensus on deepening cooperation in research and development, production and distribution in the field of medicine and healthcare. As we all know, R&D in medicine and healthcare industry has the features of large investment, high difficulty, and long cycle. So IP protection is more important. Under this circumstance, it is necessary and timely for us to pool wisdom and build consensus, focusing on the IP protection in medicine and healthcare. As we all know, since the 21st century, the world has gradually realized the positive role of IP protection in promoting innovation ability of medicine and healthcare industry. As our pioneers and leaders, Germany, France, China, and some other countries have established a relatively sound IP protection system. They emphasize protection measures on quality, safety, and efficacy of medicines. These valuable explorations and experience are worth learning. Certainly, compared with other industries, the medicine and healthcare industry needs to take the safeguard of public health into consideration. Therefore, while constructing IP protection system, we should not ignore the availability and affordability of medical products and healthcare service, because the sweeping COVID-19 pandemic has made people all over the country realize that cross-border health threats are closely linked to the destiny of mankind. Anyway, enhancing IP protection in medicine and healthcare is conducive to encouraging the research and development of new drugs. It will also contribute to improve public health and strengthen the ability to deal with health crises in the future. Today, I would like to take this opportunity to appeal to build a more fair and reasonable medicine and healthcare IP protection system and the guidance of the concept of a community with a shared hygiene and health for mankind, and push forward the construction of a more comprehensive and mature global health governance system. Finally, I wish this meeting a complete success. Thank you so much. Thank you.
Thank you. Thank you, Ms. Wei Qing. And now let's move to our expert sharing time. Today we have three experts are giving presentations on the EU SME IP protection in medicine and healthcare, and also the IP due diligence in the medical investment, and also the action which is going to be effective from the June 1st, the pharmaceutical patent linkage system in China. So first, let's welcome Mr. Matthias, who is the business advisor from the China IPR help desk funded by the European Commission, with a great topic, the EU SME IP protection experiences in medicine and healthcare. And Mr. Matthias himself, he has very strong background in both business development and intellectual property rights protection, and helped many European SMEs for their IP problems. So let's welcome Mr. Matthias.
Hello, welcome everyone. I would like to share my screen, but it says that the host has authorized me to do so. So please, we can be authorized so I can share my PPT. That's it. Is it possible to share my PowerPoint presentation? Okay, I will start.
Sorry, I couldn't see. Okay, now it's okay. Yeah.
Now it's okay. Let me see if I can share my PowerPoint. There we go. There we go. I hope it's visible for everyone. Let me see if I can. There we go. Okay, let's finally begin with my presentation. First, I will do an introduction of the China Ip Sme Helpdesk. We are an EU-funded project in which our main aim is to help EU and COSME region SMEs to think and develop their own intellectual property rights strategy when coming to China. They want to settle or if they want to do business. To do so, we have an inquiry helpline in the email that you can see in the screen. You can reach us at any time, any moment with any inquiry, and we will be more than happy to provide you with a reply, with some advices. We also organize training, workshops, webinars. We have in our website several guides and fact sheets for self-learning, so companies can check and learn about IP protection in China. These are two examples of our material that is uploaded online. Let's begin with the presentation itself. Today we will discuss about intellectual property rights in the healthcare system. First, I will do a brief introduction about what intellectual property rights are, and we will see some of them in details with some specific characteristics of how do they impact with the healthcare. When we talk about intellectual property rights, basically we are talking about a monopoly over certain specific acts. The owner of one intellectual property right, at the end of the day, what they can do is to be the only person to, for example, manufacture, export, import, or sell different type of products. Products with a trademark, products that contain certain technology protected by a patent, or products that were made with their own effort, for example, with a copyright. So there are several different intellectual property rights, and each one of them protects a different aspect of a product. For example, invention patents and utility models, what they do protect is the technology, the innovative part of a product. They can also protect those processes that can be used to manufacture the final product. When we talk about design patents, what we are protecting is how a product looks like, how it is presented to consumers, the aesthetic aspects of a product. So when we talk about how a product looks like, how it is presented, if the shape of a product is related with the functionality, then we have to protect it with an innovation patent. But if it is only how it is presented for aesthetic aspects, then we have to go with design patents. That's the main difference between those two types of patents. When we talk about copyright, what we are protecting is expression of an idea, not the idea itself, but how it is expressed, how it is told by the author. With trademarks, we protect signs that distinguish our products from the ones of our competitors. Everything that we can use to make our products more distinguished, then we can protect it as a trademark. Finally, we have trade secrets, which are normally forgotten. Trade secrets are all those type of knowledge that we have about our product, how to manufacture, how to make it more efficient, but it's not contained in any other intellectual property right. This is not registered, and also it is not known by our competitors because it provides us certain advantage. It will have value, and they should be protected with very specific measures. Also, when we talk about intellectual property rights, we have to know about two main principles. The first one is the registration principle. This means that if we do not have a registration done, we didn't register our trademark, we didn't register our patent, then we will not have any protection. Even though there are certain exceptions, for example, for very well-known trademarks, the main rule is that if we are not registered, we will have no protection. This is also combined with the second rule, which is called first to file. This means that that company or that individual that first begins the registration, we have a priority over any future registration, even though if that first registration is done in bad faith. Of course, if the registration is done in bad faith, it can be taken down. Nevertheless, it will be the real owner of the intellectual property right, the one who will be in charge, who will have the burden of proving that that intellectual property right is being copied. So with these two ideas or these two principles, we can see the importance of being the first one and to start in the registration as soon as possible. Finally, there is another important principle that is called territoriality, which means that any intellectual property right register only grants you protection within the territory of the country in which was registered. This means that all our intellectual property rights protected in, for example, Europe will not grant any protection in China, the same way the registrations done in China will not grant any protection in the EU. So it is very important for those companies that come to China to think and develop a strategy that also involves registering in China, and it's not based only in the fame that the company may have in Europe or the protection they may have done in Europe. They need to do the registration also here in China. But let's go to each one of them and make it more specific about the healthcare sector. As I mentioned before, by trademarks, we can protect any sign that help your products to be distinctive from the ones of your competitors. This means that you can protect the name of your company, the name of your product, your logo, anything that can be used to make your product distinctive can be protected. However, there are certain exceptions. If you go to the trademark law, you will see that there are certain specific prohibitions for registering. There are restrictions that are not involved or they're not related with the healthcare sector. For example, you cannot register trademarks that goes against the bad faith or goes against national symbols. And also, you cannot register those trademarks that are considered not distinctive. This means that they are too generic or that they are used to describe a product. For example, you wouldn't be able to register a trademark with the word medicine. You cannot avoid other companies to use the specific word medicine in their products, because otherwise you will be restricting them to explain what they are producing, what they are selling, and most likely will cause confusion among the public. So, for example, when we talk about medicine, we have to distinguish three different types of names. First, we have the name of the drug, the scientific name of the compound. This cannot be protected because a company cannot avoid other companies to use the name of a drug in a scientific way, the scientific name. This should be capable of the drug should be capable of being identified. It is not considered distinctive from the trademark point of view. Also, we have to distinguish the common name of a medicine, the way that normally people recognize a medicine in the street. Maybe it's not a scientific name, but it's just a short version of that long name. And it became the way that normal, regular people will refer to the medicine. It cannot be protected neither, because otherwise it will be confusing the consumers, and it will not be distinctive enough for giving the trademark its own main requirement, which is the distinctiveness. What can be protected is the commercial name that companies can give to their medicine. So companies should come up with a new name that is not related, is not very well connected with the drug name or the common name, in order to commercialize and to protect their trademark. And there is a case that an EU company faced here in China with the Shumington. It's a medicine, but it's also was a trademark registered since 2008. The problem with this trademark is that it was also listed in a drug pharmacopoeia that was published by a public administration or public institution. The name of the medicine was published under the Shumington Jiaonan, which is the full name. However, as you can see in the screen, the first 3 characters were the same, exactly the same ones that were registered as a trademark. When the patent expires, third companies starting selling the product and starting using this name to refer to the medicine. So even though the patent was expired, they tried to avoid other companies to selling the medicine under this name, using the trademark. However, when they try to enforce the trademark, they find out, or they face a situation in which the Chinese court said that their trademark was actually the generic name of the drug, and for that reason was not distinctive, and for that reason that trademark ended up being not valid and declared nullified. So that's why it's very important when companies start making their trademarks, not making them descriptive, not using the generic name, but came up with a new commercial name. In the case of copyrights, we have the situation in which, for protecting, there's the possibility of doing a registration the same way with any other intellectual property rights. However, technically speaking, thanks to the Berne Convention, an international agreement in which China is part of, the registration is only voluntary and with the purpose of being capable of proving that the product, that the final art or the final work was done in a specific date. It is not, technically speaking, necessary. However, it is very advisable. The only requirement for having copyright protection then is not the registration, but it has to be original. By original, I mean that the final work should have a minimum of creativity, but also should be should be an independent creation that can be separated or can be recognized from what it already exists. It is not important the quality of the final product. The copyright will not check if the final product is good or the final art is good or not, but at least should have a minimum amount of creativity. That's why when companies in the medical sector, they start to, for example, promoting, doing advertise, or explaining the specifics of their product, it is advisable always to increase the level of originality in the promotions or in the sheets that the companies use to explain these circumstances. The usage of pictures, of drawing is very advisable. And we will see this with an example. The leaflet or the product information sheet that an EU company used in their medicine to explain how the medicine was composed, how are the secondary effects, what are the risks, etc. The company came up with a very good explanation. It's a paper with all the details. And times later, when competitors, they started producing generic versions of that medicine, they started using the same leaflet for explaining the same circumstances. What are the side effects, the risks, etc., etc., etc. The company, in one attempt of stopping them to selling their products, they sued them with a copyright infringement. They said, this leaflet was done by our company. We have copyrights because we were the ones who wrote all these important details in this order, in this way. In first and second instance, Chinese courts ruled in favor of the European SME, saying that actually there was a copyright infringement. However, when they reach the Hunan High People's Court, this court overturned both previous decisions, saying that the leaflet had not originality. They were only providing scientific information, mandatory to provide due to the regulations. Thus, there was no creativity, there was no originality, and then there's no copyright, potential copyright protection over this leaflet. That's why it is, I mentioned before, it is advisable always to use, when possible, to include pictures, drawings, elements that cannot be argued as not original, not creative, because if you only provide scientific information, which is perfect, this is good, it is necessary, and it's mandatory, we have the risk that we will consider not being original and not having any type of copyright protection. But if we include those other elements, we increase the chances of being protected. Regarding invention patents, also there is, one of the main problems in the healthcare sector is how short normally patents are. The patent life cycle is of 20 years since filing. Then we have to analyze that most of in the healthcare sector, most of the patents, they need to go through market access checking, which also requires a considerable amount of time. Now, with the new patent law that will come into effect in the following weeks, we will see that there are two methods of extend the life of a patent in case of an administrative delay, as well in the case of the drugs industry, when companies, they need to go through the marketing approval, they may extend it according to that period of time. However, there is another way of extending this life of a patent, and is with the life of the product, how to protect the product longer than the life of a patent, because technically speaking, we're not extending the life of the patent, but yes, the protection over the product, and it's keep innovating. By the use of side technologies over a core technology, this means we have a core technology protected by a patent. If a company keeps developing new technologies that are just accessory or just complements, and they get new patents over those secondary technologies, it is possible to increase the life of the commercial life of the products. And we will see the case of Novartis with their product Defects, which was a patent that finally expired in 2013. Since it expired, generic drugs were made, and competitors started selling, create new technologies around the compound of this medicine. They keep developing and getting new patents, for example, including new varieties of crystals, getting new indication for the disease medicine. These improved versions of the medicine were commercial, much more viable than the generic old versions. So even though the main of the core technology was already unprotected because the patent expired, they were capable of having protected the most valuable from the commercial point of view medicine. And that way, this company managed to keep this Gleevec product live and protected. Some takeaway messages, because we are already finishing my presentation, is to register your intellectual property right as soon as possible. As I mentioned at the beginning, if you want to be protected in China, you have to be registered in China and do it as soon as possible. Remember the first to file rule. Check if you're using the generic name of your products as your main brand, and if you are doing so, try to register and protect and develop all your marketing strategy around a commercial new name. Give originality to your product's information sheet on instruction manuals over your products. Extend the life of your patents when it's possible, when there is an administration delay, or when you spend many years, in getting the marketing approval. And keep innovating over your core patents. It may happen that the new versions may be more competitive than the generics and will allow you to stay in the market as the main player, thanks to these side technologies, even though the core technology may be already unprotected. Of course, if you have any questions, you can always contact the China Ip Sme help desk in the email that you can see on the screen. We normally reply within 3 working days, and we are free, fast, and confidential. We don't charge anything for our services. We are looking forward to receive your inquiries and help you with your IP strategy. So here, my part of the presentation. I stay for the Q&A section.
Okay, thank you, Mr. Matthias. From your sharing, we have learned how the European SMEs to get their IP protected in China, especially in this medicine and healthcare sector. Actually, your interesting cases is quite related to our third speaker, Ms. Zhao, her topic, the pharmaceutical linkage system in China. So later on, we can also enjoy her presentation, and maybe you can exchange your ideas. So the following guest speaker is Carissa Ms. Li, the IP expert from Hainan Boao Lecheng Medical Tourism Pilot Zone Administration. She is also the president of the IP Commercialization Group, AIPPI, in China. And Ms. Li, she is not only an IP expert, but also she finished her postdoc degree research work in the Duke University Medical Center in the States. So let's welcome Ms. Li, Carissa, for her presentation. So Carissa, can you cancel your mute? You are now on the mute. Okay.
Hi, thank you very much for your nice introduction. Hi, everyone. I'm Carissa Li. I'm a Chinese patent attorney and a trademark attorney, and also a CLP, certified licensing professionals, certified by LES, US, and Canada. So I also got my law degree in both Chinese law school and American law school. And my technical background is biotech and pharmaceutical. So now, being appointed by our central government, I worked in Hainan Province, Boao Lecheng International Medical Tourism Zone, and be responsible for the medical technologies. Not so I extend my career not from their IP to their biotechnology and medical high technologies. So now I'm the deputy head in those special pilot zone. But I'm also a registered patent attorney in China Patent Agent Hong Kong Limited, because our firm is a national firm. So I can also, selected by our central government and work in for our government. Okay, so I will start my presentation today and share my screen. Is that okay? Okay. Yes. Okay, so my topic today is the IP due diligence on medical investment. So first, let me have several minutes to introduce a very specific and unique pilot zone in China. So this is Hainan Free Trade Port, Boao Lecheng International Medical Tourism Pilot Zone. And this special zone is localized in Boao, Hainan, China. So Boao, you also know Boao is also famous for its forum, Boao Asia Forum. And it is also, held by this year, even due to the pandemic. This picture shows the area of our Lecheng pilot zone. So you can see it as localized, in the Qionghai city, and with the plant area up to 20 square kilometers. And it is very near to the highway and international and the airport, only 10 minutes by car. And there are already we have already established more than 16 medical institutions and hospitals in our new pilot zone. And you see this beautiful river, we call the Wanquan River. It is a very famous river in China, especially famous in a very lovely song. So our pilot zone is also famous for our provincial policies approved by our state council. So the state council, provide 9 provincial policies to Lecheng pilot zone. It can be summarized as 4 priorities. So first priority is medical entry. Is focused on medical entry. It means that special permissions in importing medical technology, medical experts, and medical device and medicines, drugs to the pilot zone. The second priority is specific medical approval right empowered to the lung, enabling foreign capitals to invest in the hospitals and medical institutions. The third and the fourth priorities is focused on the international academic and healthcare exchange and medical research. For example, the medical research, even the clinical trial and clinical applications on stem cell and even the immunity cells. Okay. So I will talk more about the first try policy. In our pilot zone, both device and medicines that was approved in foreign countries but not approved in China can be applied in this specific zone in China. So this policy we call try first, even without approved in China. So this policy, bring bless for patients of the Lecheng. This picture shows some companies and medical device and also medicines that has been incorporated to our Lecheng pilot zone. And you can also see that for this capsules made by Pfizer, German, it was approved in in America and Europe in 2005, but not approved in China until now. But our pilot zone, incorporated this new drug in 2019, so that Chinese people can apply to such special drug only in Lecheng in China. So now we have incorporated more than 30 drugs and more than 100 medical devices into our broad Lecheng pilot zone, so that the Chinese people can use the latest medical device and medicines together with other global people. And we also shortened the approval date from 20 even longer days to 3 to 7 days. And this is also a very attractive policies. We call it, it is known as the real world data study, real world data evidence So those real-world data can apply to support the approval of this drug in Chinese FDA. We call it NMPA. So now the first real-world study, real-world data was used in pilot zone since 2019. And you see this specific drug, it is a eye clinic drug. This drug is from the Igen, and this drug was approved in China in last year, completely based on the real-world study data in Lecheng. So it is a very exciting news that not only Chinese people can apply this new medical device in Lecheng, but also the real-world study data can also help such medical device to be approved in China and used in all regions in China. And we also set up a global latest device and drug expansion. And this is, we showed the many drugs and medicals that was not approved in China, so that many people, even visit our zone, can see this latest outcome in the global pharmaceutical and medical device giant. Actually, we have a new building to set up and opened this year for the special foreign medical device and drug. And then I also following to my second part of my presentation. So it's we call it the IPDD medical device, intellectual property due diligence on medical investment. So I will talk about 5 key points of the IPDD due diligence during our medical device investment. Actually, I helped many global clients and Chinese clients to do their technical transfer or technical license during their investment and merger and acquisition. So, the next 5 key points is based on my actual experience and hope that I can share with you, and not only the Chinese pharmaceutical companies, also the European pharmaceutical companies and medical device companies. So first, I will have a very brief introduction and use the patent right as an example. So when you apply a patent and own a patent, you should make sure 5 points of your patent. First, what is the right of your patent? Second, what is the power of your patent? And third, how to commercialize your patent? And fourth, when you want to practice your product or your techniques in the market, you also should know whether you can freedom to operate your technique. So after you have a basic line of your patent and your technique, I will also came to discuss the 5 key points during the medical investment. So first, during your due diligence in your medical investment, the first point is review of IP ownership. Because misunderstanding IP ownership may result in many serious results. For example, the inability to transfer your real right, and maybe your IP value is lower than your expectation, and maybe the finally failure of your M&A. So the typical defects of IP ownership might be summarized as 3 types. The first, the target company does not possess the IP right. the second, the IP right even possessed by the target company, but this right is restricted, is limited. And the third is that the right might be jointly owned also by other companies. You know, the first is that maybe the target company want to cooperate or you want to merge is not the real owner of the IP right. So there are some small key points. I'll just give some examples for your consideration. For example, maybe the employee enjoys the patent right. You know, in American, in United States, employee is their patentee, is their patent applicant of the patent right, and the company is always the assignee. So the employee is the assigner, and the company always act as the assignee, but only assignee, not the patent right holder. So you need to check the description in the patent publication, and you need also to check their employment contract. And another example is that technical partners also have the patent right. For example, it may be a cooperative development contract, you know, between your target company and its technology partners, but based on their contract, maybe the partner possesses the patent right, not the target company you want to cooperate or you want to M&A. Another thing is that the third party owns the patent right. So please make sure carefully review the patent license contract, just if and to make sure that whether this patent can be licensed or can be transferred from the third party if the third party only owned this core technique. The second typical defects of ownership is that IP right is limited. For example, is limited is restriction by license out. So the patent is owned by target company, but the target company has already licensed those patent to other licensee, to other licensee. Yeah. For example, there are many, this shows the common types of right limitations during the M&A. For example, the license type, the license area and domain, and of the sub-license, the right to sub-license, of the ability to grant the sub-license, or even the agreement to modification of the license agreement. And also the duration, the time length of the license agreement and the license right. Also, patent right might be limited by the line and mortgage. For example, your right is linked to the company, to the bank, and the bank must also may have other rights, may have its own right on your IP. Another thing is that if your patented technology is supported by government funding, it might require other specific evaluations, for example, national security control, or the foreign license and transfers evaluation and approval. The third example is that this IP right is jointly owned by other companies. So regarding to those issues, the general principle is contact priority. But you need to clarify that whether the IP right, transfer of IP right is required by all the agreement by the all co-owners, because in in different countries, it might have different rules and different laws. For example, in United States, any co-owner has the right to license and sell this IP right to a third party or donate it to the public without the consent of other owners. The second point of IP due diligence is you need to pay attention to your region and temporal review of your IP right. For example, the region review of your IP right means that the IP rights are only valid in its own country and region and has no extraterritorial effect. The temporal review means that different rights, even different IP rights have different durations, and also different countries have different patent term extension strategies. For example, the patent linkage would be discussed by the next speaker, and also in American you may heard the PTE and the PTA and the patent dance, and in Europe you may heard the SPC for the drug patent. In China, we also have patent linkage and patent term extension in our new Chinese patent law and will be effected in the coming June. And the third point is please make sure to review the scope of your IP. So they're examining whether the scope can meet the purpose of the merger and whether it can be effectively practiced by the acquiring party. So, for example, there is the key points that several notes when you review your protective scope of your IP. For example, whether the scope of your claims of the patent is too narrow so that it cannot be protect your core technique very well, whether the competitors can easily design around their patent and modify their product to avoid the infringement. And then whether your key point, your key technology is really covered by your scope of your claims, and whether your scope is stable when challenged by other petitioners, challenged by the competitors, and then whether the action of patent infringement is easily to be detected. For example, for some method claim, it is very hard to detect it in the pharmaceutical industries. For example, we cannot, visit their plant, visit their industries to check their production line, preparation lines. The point is that your patent claim should target on infringing subject, infringing product, and infringing evidence. So our suggestion is when you request your patent attorney to draft your patent at the very beginning, just to think from the infringer, just to think of after the patent is granted and how you practice your patent or commercialize your patent. And the fourth point is, to review the IP dispute of your target company. For example, there might be the infringement by third-party IP right. So, so your target companies might infringe other parties' IP right. So you need to review the litigations that your target companies is involved, and also to identify the potential risk. you need also not only pay attention to the pending case, but also to the terminated case, the closed case, to determine whether the relevant litigations still exist to determine the degree of your liabilities. And you need also to pay attention to the potential infringing issues, because in American, patent infringement might begin 6 years after their alleged infringement. And then, and also, the FTO freedom to operate analysis is also necessary to key product and your method. And this picture shows the key point for the third party infringe your target company. So this is the issue that is always ignored during the due diligence. Because it might be hard, it's also hard to detect, to study, to search such infringement. Maybe you can review the past allegation by the target company to check whether the target company has claimed that their IP right was infringed previously. You may also review whether there are any competitors or third parties to challenge your target company's IP right. And you can also conduct the EOU search and analysis. The fifth point is review of the relevance and integrity of your IP right. The IP relevance review means that IP right is not an individual right. There might be many IP rights in your target companies. For example, we have a patent pools, we have including basic patent and improved patent. This patent might within the target companies, and this patent pool might also exist among the enterprises. The competitors might rely on the association, to stop the merge and acquisitions, because the competitors also might own other partial IP rights in your patent pools. And we also suggest you to pay attention to the IP integrity review, whether the target IP is fully covered the core technology, as I mentioned previously. So thank you very much. So I just have shared with you my experience and my practice in my past more than 10 years in the IP area, especially for the biotech and pharmaceutical investment. And please feel free to contact me if you have any investment interested in Boao-Le-Cheng, Hainan pilot zone, or if you have any cooperations or any project and questions on your IP protections in China. Thank you very much.
Thank you. Thank you, Ms. Li. That's really solid information regarding the IP due diligence. And talking about Hainan Boao-Le-Cheng Medical Tourism Pilot Zone, actually we have long working relationship with them from the last 2 years. And we have introduced and organized some European medical delegation groups to Hainan before. And we are really glad to see the new development of Hainan Boao-Le-Cheng Medical and Tourism Pilot Zone. So I believe, as I know, today in our meeting room, there are many European companies and the embassies representatives who may have the interest to go to Hainan or help your countries companies to go to Hainan. So please feel free to contact us or contact Ms. Li. We will help you to allocate your business over there. So let's move to the next topic, the pharmaceutical patent linkage system in China, shared by the expert Ms. Zhao Jing from the LLR patent trademark attorneys. They are a global offices rooted from French. And let's welcome Ms. Zhao Jing.
Good afternoon, ladies and gentlemen. Many thanks to EU-China Joint Innovation Center who invited me to this webinar and to share with you some information about the pharmaceutical patent linkage system in China. To introduce myself, I am Zhao Jing, a Chinese patent attorney working in a French IP firm. Our firm, IPR, was founded in Paris in 2000 and opened our Beijing office in 2008. So it's been over 12 years that we accompany our French and European clients to develop in China and to obtain and make use of their IP rights in China. Now let's come to our subject of today. For those who do not work in pharmaceutical field, we are going to quickly go through the reasons for establishing a patent linkage system and what is understood by this notion. Afterwards, I will briefly introduce the actual practice in China over this regard. And finally, we will focus on the new system that is being prepared in China. As introduced by Mr. Zubi-Mandi in the first presentation, the pharmaceutical industry is very dependent on patents to ensure the market exclusivity in order to recoup its substantial R&D cost in proving the safety and efficiency of a drug. Without exclusivity, most products will be immediately copied because the technical barriers to entry could be easily overcome nowadays. On the other hand, once the patent expires and the competitors are authorized to enter the market, the price of the drugs will be largely reduced due to the market competition. So the generic drugs help to improve the availability of the drugs, which is also very important for medical system in any country. Thus, there is a fundamental conflict between innovative drugs and generic drugs, and a system is needed to reconcile them so as to balance the interests of different parties. In addition, before the drug enters the market, it has to go through drug registration to get the regulatory approval. Especially for innovative drugs, this registration is a complicated and lengthy process because corresponding experiments have to be conducted to obtain adequate data, and these data have to be examined by the drug approval administrations. However, a patent right has a term period, which is usually 20 years measured from the date of filing of the patent application. The drug registration process may take a large part of the duration of the patent right actually enjoyed by the drug. Again, on the other hand, the generic drugs also have to go through the drug registration before they enter the market. And for doing so, the drugs should have been manufactured. So the question is, when can they legally begin manufacturing the drugs for the regulatory approval? If the answer is after the end of the patent term, then during the preparation period and marketing approval process of the generic drugs, the patent holder actually continues to maintain the exclusivity on the market, which is not fair. And if the answer is before the expiration of the patent, normally the manufacturing is considered as an infringement of the patent right. So can the generic drug manufacturers get sued for this special kind of manufacturing, and before which administration should the case be brought? We know that assessing a patent infringement is a very professional work. The Drug Approval Administration is not responsible for and not capable of doing this job. If a generic drug company affirms that its drug is not infringing any patent, or the patent is not valid, the Drug Approval Administration cannot decide if it is true, and thus cannot decide if the approval process should go on. Usually, it is the competent court specialized in patent who can decide. And in China, if one would challenge the validity of a patent, it should bring the case before the patent office. In case any dispute is engaged between the patent holder and the generic drug company, should the approval process of generic drugs be stopped? To answer all these questions clearly, a mechanism is needed to coordinate the actions of separated administrations, namely the drug approval administration, the patent office, and the court. So the pharmaceutical patent linkage system is such a mechanism to link the marketing approval for generic drugs with the patent of innovative drugs. It was first established in the United States through the so-called Hatch-Waxman Act in 1984. Within the framework of this act, the United States has established a comprehensive and elaborate mechanism for balancing the interests of innovative drug companies and generic drug companies. This system comprises the patent term compensation, the data protection, Ebola Exemption, abbreviated new drug application called ANDA, and the so-called patent linkage system, which includes mainly the Orange Book, the patent statement, the waiting period of 20 months, and market exclusivity for the first generic drug company. We will see it in detail in the following slide. So here is a schema showing the content of the Hatch-Waxman Act. We see here the Orange Book published by the Drug Regulatory Department, which is the FDA in the United States. So the patent owner of innovative drugs should register or record its patent information on the Orange Book, which is consulted by the generic drug manufacturers. When applying for a generic drug, the applicant for generic drug applicants can apply for an abbreviated application and should make a patent statement with regard to the patents existing recorded in the Orange Book. The filing of ANDA can be regarded as an infringement act under American patent law, and thus the patent holder may launch a lawsuit against the generic drug manufacturer if he finds that the generic drug infringes his patent. In this case, the FDA will hold the approval process for 30 months. On the other hand, the applicant for generic drug may file a patent statement of type 4, which means that he will challenge the validity of the patent. The advantage for doing so is that if the patent is successfully invalidated, the first generic drug manufacturer who did it can enjoy a market exclusivity of 180 days, well, about 6 months. Thus, on one hand, the implementation of the pharmaceutical patent linkage system can encourage the generic drug companies to resolve the patent disputes before the generic drugs are approved for marketing and reduce the risk of litigation after the marketing of the drugs. And on the other hand, it also enables an open and transparent process for approving drugs for marketing and facilitates proper assessment of the drug infringement risk to avoid unnecessary disputes. Now let's see the actual practice in China. For quite a few years, according to the former drug registration management measures, applicants for regulatory approvals were required to list out known patents in relation with their drugs and to declare that their drugs would not infringe these patents. However, there was no consequence if the declaration is wrong, and there wasn't any channel for the patent holder to challenge these declarations. As a result, this declaration mechanism did not form an effective way to resolve the patent-related disputes. Then in 2018 and 2019, the General Office of China Communist Party and the General Office of the State Council jointly issued 2 documents, the 2 opinions, in which the goal to establish a patent linkage system is established. However, it is disappointing that in the new Drug Administration Act and the corresponding drug registration management measures, there were no clause about the patent linkage system. On the other hand, in the meanwhile, from the 3rd Amendment to the Chinese patent law in 2008, Ebola exemption has been introduced in China, which excludes the manufacturing, using, or importing patented drugs or patented medical devices for the purpose of providing the information required for administration, examination, and approval from the infringement of patent rights. In other words, before the expiration of related drug patents, the generic drug companies can already manufacture the generic drug for marketing approval process without the risk of being sued for patent infringement. This Ebola exemption has long been criticized as the naked Ebola exemption, because the patent holder cannot do anything to stop the infringement, even if the manufacturing is not only for the purpose of marketing approval, but also for the marketing itself. Thankfully, from 2020, a series of measures and concrete provisions are carried out by the Chinese government. On 11 September 2020, the National Medical Products Administration, the NMPA, which corresponds to the FDA in the US, formerly called CFDA, and the National Intellectual Property Administration jointly issued the draft implementation measure for early resolution of pharmaceutical patent disputes for public consultation. The early resolution measure provides a mechanism to allow the patent owners of innovative drugs and the generic drug applicants to resolve the disputes on the validity and infringement of the patents concerning such generic drugs. This is the first time when an early resolution mechanism has been introduced into the legislative pipeline in concrete provisions. So this early resolution measure provides the following procedure, which is somehow similar to the US patent linkage system. First one is the recordal of applicable patents on the platform. The NMPA will establish a recordal platform, which is similar to the Orange Book of the US, on which the patent owners should record their applicable patents when applying for the regulatory approval for their innovative drugs, or within 30 days from the grant of the patents if the relevant innovative drug has already entered in the marketing approval process. The applicable patents for chemical drugs may be the pharmaceutical compound patents, or the pharmaceutical composition patents, or usage patents. And for biological drugs, it can be the sequence and structure patents. And for herbal medicines, it could be the pharmaceutical composition patents, herbal extract patents, and pharmaceutical usage patents. And the second one is the declaration by generic drug applicants. So the generic drug applicant, when he applies for the marketing approval for his generic drug, he is required to review the applicable patents recorded on the platform and make one of 4 types of declaration with respect to each patent. The type 1 is that no applicable patent is recorded on the platform in relation with its generic drug. And type 2 is that the applicable patents recorded on the platform are either expired or invalidated. And if type 1 and type 2 declaration is made, the NMPA will determine whether to grant the regulatory approval according to the technical evaluation. And the type 3 is that the applicable patents recorded in relation with the generic drugs are still valid, and the generic drug applicant will not market the generic drug until the expiration of the applicable patents. And if the type 3 declaration is made, the NMPA will determine whether to grant the marketing approval according to the technical evaluation, but it will add a remark that the generic drugs must not be marketed until the expiration of the patent. And the type 4 is the most exciting part is that the generic drug company, the generic drug applicants declares that although there is a patent in relationship with this generic drug, but this patent should be invalidated, or the generic drug does not fall within the protection scope of the patent. According to the early resolution measure, in this case, the generic drug applicants must also file supporting documents alongside with the declarations, but which documents are not specified yet. So once the declaration is published, a patent owner may initiate a judicial proceeding or bring an administrative action within 45 days if he does not agree with the declaration. If the filing of such legal proceeding, judicial proceeding, or administration action is accepted, the patent holder should submit a copy of acceptance notice to the NMPA. And in this case, a waiting period of 9 months is given during the marketing approval process of the generic drug. The waiting period begins from the acceptance of the judicial proceeding or administration action. During the waiting period, the NMPA will not suspend the technical evaluation of the generic drug, but will not grant a marketing approval for it. If within the waiting period, the judicial proceeding or the administrative action confirms that the patent covers the generic drug, the NMPA will suspend the marketing approval process until 20 days before the expiration date of the patent. Or if the judicial proceeding or the administrative action confirms that the generic drug does not fall within the protection scope of the patent, or the patent is not valid, the NMPA will continue the marketing approval process. And if no judicial proceeding or administrative action reaches a decision within the waiting period, the NMPA will continue the marketing approval process after the expiration of the waiting period. And finally, if the applicable patent is successfully invalidated by a generic drug applicant, the same person will enjoy a market exclusivity of 12 months or the remaining term of the patent, which has been successfully invalidated, whichever is shorter. So during the market exclusivity period, the NMPA will not grant marketing approvals for subsequent generic drugs of the same compound or composition or usage according to the time of the invalidated patent. The introduction of the market exclusivity period indicates the government's intention to encourage the development of generic drugs. To compare with the United States patent linkage system, we see that waiting period of 9 months is much shorter than the 20-month stay in the US. In fact, different countries have set different waiting periods. For example, in Canada, it's 24 months, and in South Korea, it's 9 months too. Can this 9 months be too short? Maybe. According to actual practice, the Beijing IP Court is usually, which is the unique jurisdiction for this kind of disputes. Beijing IP Court is usually overloaded, so it could be difficult to complete the litigation in 9 months. And another difference is the duration of market exclusivity for the first generic drugs. Compared to the 180 days in the US or the 9 months in South Korea, the 12 months in China is relatively long and should encourage the generic drug manufacturers to challenge the innovative drug patents. And another difference is the monitoring. In the US, the generic drug applicants who submit the type 4 declaration must notify the patent holder in a timely manner. The patent holder has 45 days to file a lawsuit. The 45-day time limit starts from the date when the patent holder receives the notification. While in China, the generic drug applicant does not have to actively notify the patent holder. Therefore, in order to initiate the litigation in a timely manner within the 45-day time limit, the patent holder should pay close attention to the NMPA's publication of the application and declaration of generic drugs. And later, 2020, in October, the 4th Amendment to Chinese patent law has finally been approved and will come into effect from the 1st of June this year. The newly added Article 76 will serve as the legal basis of patent disputes during the marketing approval process of generic drugs. The disputes can be resolved by filing a lawsuit with the People's Court or requesting the Patent Administration Department for an administrative decision. Here, please note that the Article 76 only mentions the lawsuit or the administration, the lawsuit to decide whether the generic drug falls within the protection scope of the patent and does not mention the validity of the patent. It is because the validity of the patent is exclusively examined by the Chinese Patent Office, which is different from some countries. A few days later, after the publication of the 4th Amendment to the patent law, the Supreme People's Court issued a document named Provisions on Several Issues Concerning Application of Law to the trial of patent civil cases involving the evaluation and approval for drug marketing. That is too long. Wherein some clarifications are given. For example, all the cases under the new Article 76 should be filed with the Beijing IP Court, and only the patents recorded on the platform are applicable. According to the Article 12 of the provisions, the decision of the court should specify if the generic drug partially falls within the protection scope of a patent. And finally, under the new Article 76 of patent law, both judicial procedure and administrative procedure can be launched. The provisions issued by the Supreme Court stipulates that an ongoing administrative procedure will not stop the judicial procedure. However, according to the draft measures provided by the Chinese Patent Office, if the case has been accepted by the Beijing IP Court, and the Patent Office will not accept the case once again. Thus, 3 routes are available for the litigation strategy under the Article 76. It's only the administrative action or only the judicial action or both actions. But in this case, you have to pay attention to the starting time of each proceeding. The advantages and disadvantages of different routes are still to be observed. And And a related issue is the patent term compensation, which is also newly added in the Fourth Amendment to patent law. Strictly speaking, it is not part of the patent linkage system itself, but it is also an important part in the balancing of interests of innovative drugs and generic drugs. We see that in order to compensate for the time taken by the marketing approval of patented drugs, China has also established a system for extending the term of drug patents so as to avoid the shortening of the effective patent term caused by drug registration, and thereby encouraging the pharmaceutical companies to continue investing in R&D of innovative drugs. Similar to the rules of the United States, the extension period is not more than 5 years, and the total effective duration of the patent right shall not exceed 14 years from the marketing of the new drugs. And later in November 2020, the draft implementing regulations of the patent law provides in detail the method for calculating the extension term and the scope of protection, the definition of new drugs, and the time of filing the extension request, and so on. We will not develop all the details herein because the time is up. So thank you for your attention, and open for the questions.
Okay, thank you, Ms. Zhao, for your professional sharing. Let us understand what is the pharmaceutical patent linkage system and also the differences between China and the States. Actually, I just checked our live stream platform. We have now over almost 1,500 audiences are now with us. I believe they have enjoyed all your professional presentations shared today. Actually, it's already exceeded my expectation. Hereby, we move on to our live Q&A session. Before we start, I would like to thank all our speakers once more for their great insights. So let's see what questions do we have here. So now we are open for the Q&A sessions. Okay, we have one question for Mr. Zubimandi. So for the case Novartis, you mentioned that Novartis has developed new relevant patents to improve the original core patent and correspondingly maintained the sole rights of the medicine production. We also know that generic drugs are allowed after the patent expired, which is in fact an indication of corporate social responsibility. Generic drugs for the greater good and thus contradictory to the company interests. So how do you perceive this contradiction, and how do you think the role of the government in balancing these two aspects?
I don't see any contradiction actually, because the generic drug is based on the expired patents, and the new protections are regarding additional and new technologies that can be complementary to the already expired patent. So when the patent expires, that technology can be replicated, that medicine can be done in a generic way. The new patent is going to protect only the new version, the new improved, the new aspects of the technology. For example, when they came up with different way of crystals, then the new crystal is protected, but the old one was not protected. It was possible to do a generic version of it. The use of new technologies in order to extend the protection of the products, to extend the commercial protection of the products, is important as long as the new version is commercially much more interesting than the previous one. I think I don't see any contradiction on on the generic version and the possibility of having new technologies, new patents that will protect the new commercial products.
Okay. Hopefully this Yan are satisfied with this answer. So now we have another audience with us has a question for Carissa. The Chinese central government has recently published so many influential policies related to Hainan Free Trade Zone. So what's your prospects for the future development of Lecheng International Medical Tourism Pilot Zone? So welcome, Carissa.
Okay, thank you very much. Thank you, Mana. Sorry, I don't know how to call your name, but thank you very much for your attention to our pilot zone. Yeah, you are correct. You are definitely correct that our central government provide many specific and exciting policies to Hainan Free Trade Port. So in my personal opinions, there will be great development and great chance in Hainan in the next several years. For our Lecheng pilot zone, we have the new policies on internet hospital, and we also encourage our hospitals and institutes in our pilot zone to develop high-tech, high quality medical device and drugs. So also as I mentioned, the real world study RWS, it is very this policy has attracted almost all global giant pharmaceutical company to cooperate with our pilot zone. And as I also discussed with many investors previously, so Lecheng pilot zone is also advantages to medium-sized and small-size European medicine companies and medical device company. I know because I know that even for the small size or medium size pharmaceutical companies, they have their very top level match funding or match employees to invest to study all of the policies and all the all the global market. So our Lecheng can help them to at the first station to enter China, because their products, their medical device can be first applied in Lecheng, even it is not approved by Chinese government. And with the application of their products, we can also help them to set up their own Chinese branch in China and set up and localize their IP right, patent, trademark, and even copyright in China, and extend their business to China. So that is a very great opportunity, great cooperation opportunity between Lecheng and Europe companies. So thank you very much.
Okay, thank you. Thank you for the question from Double O. And let's have the next question to Ms. Zhao Jing. Regarding the pharmaceutical linkage system. There are remarkable differences of the patent linkage system between China and the US, such as Chinese developer has less waiting period, but more market exclusivity period. Also, from informing the patentee, which actually disappoints the innovative developers. Are there any measures protecting the original developers for the better, or what are the specific reasons behind these decisions?
Well, thank you for your question. I think for the first question, the introduction of the patent linkage system is already the best news for the innovative drug companies, because before this amendment to the law, there was even no legal basis for the an early resolution of disputes during the marketing approval of generic drugs. And what is the good news for the innovative drug manufacturers is the patent term extension, of course, because we see that on the last point, it is not, as I said, it is not a part of the patent linkage system, but it's also a very important part in balancing the interests of generic drug manufacturers and innovative drug manufacturers. And for the specific reasons, I think the system is being established according to a specific country's status and the development and where it is standing. What I mean is that before 2008, there was no Ebola exemption, and the Chinese patent law, in fact, exists only for less than 40 years. So China is a developing country, and the Chinese patent law is also developing with this with our country. So I think it is the government's intention to encourage both the generic drug companies and innovative drug companies, and it's the country's balancing point at this moment. I think it could be developing in later years, but for the moment, I think it's the it's the balancing point. Thank you.
I see Carissa also would like to answer the same question. So maybe Carissa, you can also add something.
And thank you, Jing Zhao, for your excellent answers. I just want to add my personal comments on those questions. So because I was a Chinese patent attorney and invited to attend many discussion and forum held by Chinese Patent Office. So I also involved in the amendment of new Chinese patent law. So I just want to share with my experience during the amendment of such Chinese patent law. So, I definitely agree with Zhao Jing that, China is still a developing country, and we need to support our domestic company at the first importance, because every country has their own national benefit, national interest. But I want to mention that, especially for the biotech industry, for the antibody industries, Chinese companies have their many new drugs, many original drugs of antibodies. Many drugs has get the FDA approval. So Chinese government also discuss the balance between our own original companies and our own domestic generic companies. So the first, that is the first consideration. And the second consideration, I mentioned that maybe Chinese developers have less waiting period, 9 months, less than US. So during this Chinese patent law amendment, we reference to not only US patent system, that also EP system, JP system, and Korea system. So we started global patent system to not only US system. And our new Chinese patent linkage system, we called early resolution before the patent, before the drug is approved. So we have to make the process as short as possible to solve this problem before the drug is approved. So we want to provide the generic company a shorter waiting time, and we also, to require the Beijing IP Court to finish those even the appeal case or even this litigation as short as possible. So that is a very hot topic, because we just curious whether Beijing IP Court can complete this case in the required time, because we also have the statistics of our IP litigations period by Beijing IP Court. And we also know that this appeal can also be appealed to the Supreme Court or IP Court. So that is also a discussion. So whether the second instance of such litigation will be resolved very quickly. So okay, that is my comment. So that I also agree with that is a balance, but that is also the balance between the domestic original company and the domestic generic company. So as we discussed, for the previous amendment of Chinese patent law is always were always pushed by foreign countries. For example, China want to join the WTO, or China want to to join the TRIPS, to amend the PCT treaty. But this time, the amendment is pushed by Chinese own development. Thank you very much.
Okay, thank you, Carissa. I saw there is also some friends in our meeting room are quite interested about Boao Lecheng medical pilot zone. However, our time is quite limited. Actually, you can contact us and contact Carissa later on after our webinar. Thank you all for your participants today. And we shared today so many grateful, valuable insights about intellectual property protection in the medicine and healthcare. Hopefully these insights could give you some instructive advices on your future business. Later on, we will release our QR code from our WeChat, Weibo, and website. You can follow us, and you will see more interesting webinars and activities upcoming. So thank you all today for your participation again, and your ideas and your willingness to connect with Hainan to reach us via our WeChat and our email accounts. Thank you. Thank you all for today. Thank you.
Bye-bye.
Bye-bye. Bye-bye.